Okay, Maria, you can share the screen and Judge Nally will be reading Article 2.
Okay.
Thank you.
All right, we're going to jump right in here today with paragraph 1 of section 1 of Article 2. I know this one's going to be real hard for y'all to understand because it is so extensive. But it simply says that elections by the people shall be by secret ballot and shall be conducted in accordance with procedures provided by law. Now, you got a problem with election procedures, you know who to take it up with, your state legislators. That's pretty simple. One thing I would like to point out that I have not pointed out before, and that is for those of you who are able to access the legislature's link to LexisNexis on the General Assembly website. When you bring up these code sections and these paragraphs of the Constitutions, if you scroll down below, some of these have research references and practice aids, and they also have select judicial decisions that help explain the paragraph. So I highly recommend that anybody who's going to research the Georgia Constitution or the Georgia statutes try to get that LexisNexis link on your browser toolbar, because that can be exceedingly helpful. Now, let's see, we're going to jump off of paragraph 1 and we'll jump over to paragraph 2. And that has to do with the right to register and vote. Well, it seems that this modifies slightly paragraph 1, because now the Constitution is telling the legislature that when you start your rule-making process for elections, there's some things you need to pay attention to. Paragraph 2 provides that citizens of the United States who are residents of Georgia, and that residency, by the way, is as defined by law. So you can't just own a home somewhere in the state of Georgia, come visit it a couple of weekends a year, and be classified as a resident. There are rules in our code sections that do determine how you are a resident. You must be 18 years of age and not disenfranchised by this entire article. Now that's Article 2, all of it. And you must have the, that's the residency requirements as provided by law. So the General Assembly shall provide by law for the registration of electors. So there's another duty to your General Assembly. Now we'll jump over to 3. And when it comes to registering to vote, paragraph 3 has some exceptions. There's only 2 of them. No person who has been convicted of a felony involving moral turpitude may register, remain registered, or vote except upon completion of the sentence. Now, there's a couple of things there that you need to understand. If any of y'all happen to have a little still set up out back or maybe over the hill from your house, and you like to run off a nip or two every once in a while and share with your neighbors. If you get caught and convicted of moonshining, you can still vote. Yeah, that used to be a felony in this state. The problem is making moonshine is not a crime involving moral turpitude. Theft is. Armed robbery is. Murder is. So you can't vote. But if you're out of jail, well, it really doesn't matter whether you're in jail or out of jail. If the crime you're convicted of is not involving moral turpitude, then you can still vote. The next provision is there's no person who has been judicially determined to be mentally incompetent may register, remain registered, or vote unless the disability has been removed. What they don't say there is by a court of competent jurisdiction. So the next thing I would like to call to your attention in both of those provisions is that phrase, remain registered. Now, does that mean that if you're convicted of a felony involving moral turpitude or you're an incompetent individual, does that mean that they have to remove your name from the voter registration list? Every occurrence of your name. That is an interesting question, ladies and gentlemen, for which I do not currently have an answer. And I certainly didn't when I was reading to get ready for this class. When I went down to those judicial decisions down at the bottom, I didn't find any mention of it. So now that's going to require a greater amount of research. But for those of you who may be involved in the poll book questions, that may be something you want to look at. You know, you might be looking at a registration list, a list of registered voters, and there might be a section of that list that is designated retained, but currently disqualified, or some language to that effect. In accordance with the federal law, then you might want to look and see if any of them are convicted felons or if they're mentally incompetent, and question whether or not those names should even remain on the list, the voter list, or whatever it is they call that, the poll book. But anyway, that's something for y'all to look at. And if you happen to be working on a regular basis with your board of registrars, you might pose that question to them, because they in turn can pick up the phone, or they can send an email to the Attorney General and get an unofficial Attorney General's opinion about whether those names should even still be listed. Just an interesting little sidelight there on paragraph 3. And now we'll move right along to the second section, general provisions, and we'll look at the procedures to be provided by law. Well, lo and behold, our Constitution's telling our legislators how to do their business. Imagine that. Okay, the General Assembly shall provide by law for a method of appeal from the decision to allow or refuse to allow any person to register or vote, and shall provide by law for a procedure whereby returns of all electors, all elections by the people shall be made to the Secretary of State. So there they're giving the legislature some instructions. And of course, one of those instructions is to pass a law that would cover those previous two instances that we spoke of. Now, right off the top of my head, I can't recall a provision in Chapter 2 of Title 21, but I'm sure there's one there somewhere, although there may not be. Also, if you happen to be using the LexisNexis and you scroll down, you'll notice that there are no case laws referenced under that particular provision. So we'll get out from paragraph 1, go down to paragraph 2, and we're going to find there that runoff elections are defined. And there's going to be an interesting little concept in here that those of you who do work closely with or keep an eye on your boards of elections and your poll workers and your election supervisors. Paragraph 2 provides that a runoff election shall be a continuation of a general election. Now, here comes the interesting part. Only persons who were entitled to vote in the general election shall be entitled to vote therein. Now, what does that mean exactly? Well, the language is fairly straightforward. Only those persons who were entitled to vote. Does that mean only those who voted in the election? Or does it mean all of the registered voters in the county? Well, I would submit to you that every registered voter in the county was entitled to vote whether they did or not. So it's entirely possible that you might find in a regular election 15 or 20 names that did not appear as having cast a ballot in the regular election. Then all of a sudden, in a runoff for that very same office, their names appear. You really don't have a worry with those names appearing as long as they are legitimately registered voters in your in that particular precinct. Got a question, I think.
Yes, sir. Could that language also mean you have to have been registered prior to the certification or prior to the cutoff date for the general election?
I swear, Ted, there you go.
Register to vote.
There you go, Ted, thinking outside the box again. That's exactly what it means. If they were not eligible to vote in that particular election, they cannot vote in the runoff. Now, that's the language of your Constitution speaking. Now, that you might want to pay attention to. Thank you, Ted. All right, let's see.
My pleasure.
Yeah, I know it's your pleasure. All right, now we're going on further to number 3. And here is one. Oh, it's a little bit longer than the rest. But there is language here that you're going to find in other places in our Constitution. And you might want to pay attention. No person who is not a registered voter who has been convicted of a felony involving moral turpitude. Don't forget, you can be convicted and spending time as a bootlegger, but that's not moral turpitude, so you can still vote. Unless that person's civil rights have been stored and at least 10 years have elapsed from the date of the completion of the sentence without subsequent conviction involving moral turpitude. Now, here's another. Wait just a minute. Let me see if 3. Yep, there we go. Now you'll notice there's some semicolons in here, and that's going to indicate a different requirement, a different element. And by the way, in any statute you read, there are what's called elements of a law. And an element is simply a statement of a condition that must be met or not met, which indicates that evidence needs to be presented at trial to address that element so that a conviction or an exoneration can be had. So in this particular case, the very first element is no person who is not a registered voter. That's the first element. The next element is who has been convicted of a felony involving moral turpitude. And then we go down to the semicolon, and that's your second element. The third element starts off who is a defaulter for any federal, state, county, municipal, or school system taxes required of the office holder or the candidate, if such person has been finally adjudicated by a court of competent jurisdiction to owe those taxes. So just the fact that they owe taxes is not a reason to challenge a candidate for an office. If, on the other hand, there is a court case which says the ruling of the court is, yeah, he owes the taxes, then no, he cannot be considered as a candidate. And then you go on down to the, well, in this case, you go to a comma after the authority pursuant to a payment plan. And you come to the next element. Under such other conditions as the General Assembly may provide by general law. So basically, all that's saying is if you want to find out who can be a candidate for a public office or hold an office, then not only do you look to the Constitution, this paragraph 3, but you also go to your statutes, your Georgia code, and you will look under probably Title 45, Title 50. There should be some disqualifications mentioned there in those two statutes, but those are the three main places you go is your Constitution and your statutes to find out who's eligible to run for or hold an office. Now let's see. Okay, now, boy, this next one. Got a little story to share with you on this next one. The next one says, or who is the holder of public funds illegally? Well, permit me to share a little story with you. There is a place you can go on the Ethics Commission website, and it lets you look up by name, by last name, a list of folks who share that last name. And you click on the links by that name, and it will take you to a page that lists every time they were supposed to file a report with the Ethics Commission. And it tells you if they did not file it, it tells you that. Even if they did file it, but they filed it late, there was assessment of a fee. It's $125 a shot. And if they didn't, then there's another column that will have that $125 in it. Down at the bottom, there is a tally. I ran across a county commissioner, and I apologize now, I've done forgotten the name of the county. But at any rate, he owed $1,500 and something in fees he had not paid. Now, when you get that kind of a number, now you have a personality who just doesn't care. And any taxpayer down there should be looking at that list and deciding whether or not they need to keep that gentleman on or not. They might ought to retire him and put him out to pasture. And the reason for it is this. And this is where your knowledge and understanding of your criminal statutes come into play when you are managing your government. There's a provision in our statutes that says that when you go qualify, you have to sign an oath that you are in fact qualified. And part of that oath says that you are not the holder of any public funds. Well, it just so happens that anytime the state of Georgia sends you a notice that you owe $5, $10, $50, $100, it doesn't matter. When they send you notice that you owe them, that $10 or $5 or $100, even though it is in your billfold at that moment, it ceases to be yours. It immediately, upon arrival of that notice, becomes public funds. Now, the legal way to challenge that, of course, is to go into a court with a challenge. Hey, judge, state says I owe them $50 and I don't owe them. And I have sent a notice to that effect to the agency, and they're here today, and I demand they show proof that I owe them the money. And then you have a court case. And that is a legal way to challenge whether or not you actually owe the money. The neat thing about that court challenge, though, is this. If that happens during your approach to the local Republican Party or the local Democrat Party or the Constitution Party of Georgia, whoever, and you're going to qualify and you sign that statement that you are not the holder, that you are not illegally holding public funds, that can be a truthful statement, even though you haven't paid it out yet. And the reason for that is there is still a case going on. So you're no longer illegally holding that money. You are challenging the state's authority to claim it. So you're not lying about it when you sign that oath. On the other hand, if you have not filed a claim in court, or in the case of the Ethics Commission, they have a request for a waiver document that you can also fill out and submit. But if you've done that, if you have filled out that waiver and sent it in and it is still pending, a decision is still pending, then you can go ahead and sign that affidavit, that oath. So there are ways, legal ways, to keep from being illegally in possession of public funds. But I would also share with you that a couple of elections ago, I started running members of the House and Senate through that website, that ethics website. When I was through, I found that just before the election, there were 28 or 29 representatives and senators who were the holders of public monies. One of them owed $500. I mean, he had a tab that ran back to 20, I think it was 2015, 16, 17, somewhere in there. So what I did, I filled out a petition to the General Assembly this last session, asking the legislature to impeach those individuals. And lo and behold, guess what? I still ain't heard from that petition. And you wonder why your legislators don't want to pay attention to the ordinary citizens? Yeah, right. So anyway, the problem is this. If you sign that oath, oh, and by the way, I included 2 judges in that. One of the judges had to go dig into her pocket and come up with that $125. She paid hers. She was late. She paid it, but it didn't help her. And the reason it didn't help her was because at the time she filled out the oath that she was not the holder of public monies. She was, in fact, holding public monies illegally. She had not filed a challenge in court, and she had not requested a waiver. So here's the problem. She still violated that oath. And the problem is the violation of an oath of office in this state is covered under 16-10-1. It is a 1 to 5 year felony. There is no fine. You cannot pay a fine. If you're convicted, you're going to spend 1 to 5 years, whatever the judge figures out you need to serve. So now we have an unindicted felon. I'm sorry, we got 2 unindicted felons on the bench here in Bartow County. Whoopee. Not a big surprise to anybody, I'm sure. So anyway, let me hush with that little bit of history, and I'll close this. No, I don't want to save it. Okay, so anyway, that ought to pretty well cover paragraph 3. But hopefully you will understand that when it comes to anything that's required here in the constitutional language, you need to follow up with in your statutory law, because under this, paragraph 3, for example, if you know of someone who has not, who is holding public funds, for example, or who has not paid taxes, if you want to challenge them, if you don't want to send them to jail, but you do want to get them out of office, then you have an option we'll look at here a little bit later called the recall. But you also have a writ that you can file in Superior Court, and it's called quo warranto. Quo warranto is nothing more than a challenge to the right of an individual to hold his or her office. And of course, that's going to be about $200 out of your pocket to file it. And it'll be probably miss a day at work to show up in court and argue your case and show your evidence. But that's just another way of going about removing a public officer without criminally prosecuting them. So we'll get out of paragraph 3. Does anybody have a question before we move on? Hearing none, I'll go to paragraph 4. Oh boy, I thought I would. Okay. And here again, we have the commandment to the legislature, make us some laws. And that is essentially what this paragraph does. It tells your legislature to provide by general law for the recall of public officials who hold elective office. The procedures, grounds, and other matters relative to such recall shall be provided for in such law. So that means that you've got to go over to the Georgia statutes and search for the recall statutes and read those so you know what you can claim and what you can't claim. Pretty simple and straightforward. Now, this one does have 3 judicial decisions down at the bottom of that page if you're on LexisNexis. But I don't think we need to indulge those right at the minute. And let's see, 4, 5. We'll go down to paragraph 5. All right. Vacancies created by elected officials qualifying or for other office. Now, this basically outlines the policy about what to do if an elected official's coming up for re-election and he decides he wants to qualify for other office. And this provides the time limits for let's see. Okay. That's pretty much straightforward language also. So each of you can read that one. There are a couple of judicial decisions, and there are several opinions of the Attorney General that are also listed down at the bottom. Any questions there? Hearing none, we'll move right along and go to section 3. Now, there is a biggie. And the very first thing I would like to call your attention to is that subparagraph A specifically defines a public official. that public official definition is not to be applied throughout the entire Georgia code. The only time this public official definition is used is in this provision, and it's going to be used again. I think it's in Article 3 of our Constitution. You'll see it mentioned a couple of times in the Constitution. But when you stop and think about, well, everybody knows the governor, the legislators, the lieutenant governor, the attorney general, these are all public officials, but we also refer to county commissioners as public officials. Well, that definition of public official will be covered in probably Title 45. I don't recall exactly, but I'm pretty sure it's in Title 45. So just remember, if you're trying to bring a case and you want to mention your Constitution and your case is against a county commissioner or a sheriff, and don't cite Article 2, Section 3, Paragraph 1 as an authority for a public official, because the judge will throw you out. He'll throw out your complaint. But it's Paragraph B is rather extensive in its procedures to be followed. But now keep in mind that in spite of the fact that you have oh, I knew there was something I wanted to say about this. Yes, I know y'all probably get tired of hearing me harp on grand juries, but there is something you need to know. Let's see, how long ago has this been? About 10 years ago, maybe 12. There was a case over in Rome, Georgia. It came out of Floyd County grand jury. And they were just, I mean, they jumped on the poor attorney general with both feet. But guess what? Yeah, the courts came to the attorney general's defense. And the judge pointed out that the grand jury in Floyd County did not have jurisdiction to be sticking its nose into state affairs, state agencies. Oh, really? You mean the judge actually put that in black and white? Well, yeah, he did. But I want to call your attention to the fact that here is your Constitution, and it is making it plain as day that yes, your grand jury can stick its nose in state agencies' business. Otherwise, there would not be this provision for upon indictment for a felony by a grand jury of this state or the United States. Now pay attention to this, which felony indictment relates to the performance or activities of the office of any public official. Wow. What greater authority does your grand jury need to rely on to go stick its nose into the governor's business, to stick its nose in the business of the Supreme Court of the state of Georgia, or the Court of Appeals, or the Superior Court, or the sheriff? There is the authority for any local grand jury to stick its nose into the government's business when they are looking into the performance or activities of that office. Kind of makes you wonder what that judge was talking about in that Floyd County case. Well, actually, you can wonder about it, but I think everybody with a lick of common sense knows he was open. Nobody read it. So he could use it to cover up some questionable activity. But you need to pay attention to these words and phrases, ladies and gentlemen, have meaning. They have very serious meanings for your elected public servants. It is, these words become the reins of a team of horses, and you're sitting in the driver's seat. You are the sovereign. You are the constitutional superior. Everybody else is your constitutional inferior. And I know they don't act like it sometimes, but they know they are. Just like that attorney, municipal judge down in Savannah the other day. Oh, yeah, I'm chairman of the board. Well, you may be, but you're a public servant. And that lady standing up there in front of you is reading her speech, quoting a public document, the grand jury presentment, issued on March 1st, 2023. And you want to shut her up and have her drug out like a sack of taters? Well, we'll see what a we'll see what a petition to the grand jury for contempt brings. Oh boy, is it time to notify your errors and omissions carrier. All right, now let's see, where did we get to? Oh, procedures, suspension and removal. Ah, okay. Section 3, paragraph 2. Suspension upon felony conviction. Now, oh, by the way, notice this. You've got two separate sections here. One of them deals with what you do to the public official on indictment. Now, this one is dealing with what do you do with them once they're convicted. And I would encourage you to read it carefully. And while we're on this, and I need to share this with you folks in case you are ever subpoenaed to show up in court on a Monday or a Tuesday morning to be possibly selected and sworn as a grand juror. First thing you need to know is, as we mentioned earlier back in Article 1, you become a member of a tribunal of judges. Yes, you become a judge. No, there is no argument. Yeah, lawyers want to, and judges, they'll want to say, oh, well, yeah, but they're quasi-judicial officers. They're not real judges. The hell you ain't. That is just, it's not deceptive verbiage, but it's darn close, depending upon the tonal inflections that are used in referring to that phrase of quasi-judicial officers. But you are still judges. As judges, you have always, in every case, a decision to make. Sometimes you should not sit as a judge in a particular case. You may be related within the statutory limits of relation to the accused, either by marriage or blood. And if that's the case, you have a duty, not because you're biased or prejudiced for or against that accused individual, but simply because you want to prevent even the question of a bias or prejudice even being raised, both before the grand jury and later at trial. So it's imperative to know that judges don't concern themselves so much with an actual appearance of impropriety, an actual impropriety. They're mostly concerned about the appearance of a questionable relationship. Appearance in a courtroom is everything for a judge. It is everything. His tonal inflections, his reactions, everything about a judge has to be viewed as equal in a condition of equilibrium. But anyway, I'll hush on that, and we'll leave that for a moment. And well, we're not doing too bad. 46 minutes. So this would be a good time, I gather, to go back over Article 2 and its 3 sections and see if anybody has a question. Well, I hear crickets.
Hey, Judge.
Hey,
Hey, on section 2 and then the paragraphs 1, 2, and 3, you had quoted a code 16-1, but I didn't get it all written down. I believe it had to do with the conditions, like the holder of public funds illegally.
okay.
I had typed a question. Did that have to do with like a parking ticket, traffic ticket, red light ticket, something like that? Is that considered?
Actually, yes.
Okay.
Anytime a governmental entity sends you notice that you owe X number of dollars. Wait a minute. Let me back up. The answer to that specific question should be no. Simply getting a traffic ticket is not an assessment of monies. So until a court hears that traffic ticket case and either assesses or doesn't assess some amount of money as a fine, there's no money that is being claimed by the state. So just having a traffic ticket, no. If on the other hand, you go to traffic court, the judge says, well, you owe $50, and you say, well, I ain't got it on my hip right now, Judge, but give me 2 weeks and I'll have it. And he says, okay, that ain't going to happen. But I don't know, some of these South Georgia counties, they're kind of laid back bunch of folks. And the judge might say, okay. And in the interim time, you go qualify to run for county commissioner and you're still owing that money. You haven't paid it. So yes, that would be a case where you would not be qualified under the terms. Does that help?
I guess so, and we have 2 more questions.
Sure.
Victoria?
Yes, Judge.
Yes,
I-
Judge.
I don't know how to make it not echo. How do I make it not echo? Are we good?
It sounds good to me.
Okay,
Yeah,
I'll keep going. I want to get back to recall. There have been efforts to recall some of our, well, especially the Secretary of State, and they have not succeeded. I understand that it's saying that the law procedures are determined by the law, and I admit I have not looked up the law recently about recall procedures. But what are our options to make that a doable thing? I can't believe that the citizens of this state who are in such opposition to the Secretary of State and can't rely on election to get him out. I can't believe we don't have a viable recall option.
Well, it takes a lot of money to get that many signatures, so you file like an intent. It's been a couple weeks since I read it, so you file an intent to do the recall, and I believe that took 150 signatures, which is doable, but then you have, if I remember right, it's 90 days to collect a percentage of how many voters were registered for that election, in which the most recent election where he won, or the most recent election. So it does take a whole lot of signatures in a limited number of time, and then you're faced with the opposition to the petition. So it's not easy that way. So like the steps is first you submit an intent to do the recall. It needs to get approved. So there needs to be due cause. A judge needs to determine that, and then you have a limited number of time. If I remember right, I'm gonna look it up really quick and have the answer by the end of Judge Nally's class.
Well, if I
get-
may,
90 days to get the signature.
if I may, yes, it does take a lot of money. It takes a lot of footwork. I was involved in one about 30 years ago, and it's extremely hard to do to recall a public official. Now, based upon what I've learned over these last 30 years, there may be an alternative, and that is if they want to go, if a group of citizens in a county want to go through a recall, go through all that headache, what they might do is when they draw up their recall petition, they might attach to it a small questionnaire. Do you prefer the recall as a method of removing County Commissioner John Doe? Or do you prefer taking the matter to a grand jury? Keep this in mind. If you remember nothing else about the Georgia Constitution, remember this: your grand jury has the authority, both of the common law and the positive law in black letter law, to stick their nose in anybody's business. That's you and me, folks. You know, we're sitting around here chit-chatting on a Zoom meeting, but if somebody on that grand jury or several somebodies think that Paul Nally might be involved in a little hanky-panky and they better look into it, they can start an investigation of me. And they don't have to tell me they're doing it. They better not tell me they're doing it. So, you know, you're not, if you think you're secure, yes, you are, up to a point. But if the grand jury ever decides we just need to look and see if Paul Nally's doing something, they can come find out. They can start an investigation. And I'll yield.
Thank you, Judge.
Excuse me,
I'm
would
just-
that be where the notion of, because it's written in our constitutions that we have the right to abolish, amend, do whatever with the. as
Yes,
we
ma'am,
see
you
fit?
do.
Okay, but is that kind of where that comes to meet?
Yeah, it meets at the grand jury. The grand jury, ladies and gentlemen.
Yep.
If you try to conceptualize of a great organization, a big organization, and that organization provides that at all times you have the right to amend or reform that organization, and you start trying to conceptualize man, you can't get everybody in this organization to agree. I mean, that's one of the lessons of history. There's never been, that I know of, 100% agreement in any large organization. Never. There's always somebody to disagree. But if you look at it and you say to yourself, there ain't but one way to remedy this atrocious behavior of this governmental entity. So I'm going to reach up over the mantle and I'm going to take a death grip on the Second Amendment. Well, you don't want to do that. Yes, you can. You absolutely can. You have that right. Even Abraham Lincoln understood that, in spite of the fact that he created that conflict of northern aggression. But be that as it may, we still have that right. But the civilized method is what shows the genius of our founding fathers. They reached over into the common law that they lived under for years, and they saw the value of taking a grievance to a group who is clothed by law with the authority to make a difference. And they discovered that in the grand jury, or they knew it. They learned it was in the grand jury, and they brought that over into Georgia, and they set that sucker down in our Constitution, fully clothed with all of the powers, duties, and responsibilities known at that time to the common law. And our people, bless Pat, had already been using it ever since Oglethorpe set foot on this, set foot on, what was it, Yamacraw Bluff. That is a powerful group of our neighbors, and they are clothed with the law, the consent of all citizens in this state to be judges of the law and of the facts. I'll yield. I'll get off this stump.
Well, and I would say that I feel that that is where our true strength lies, in not necessarily in the statutes, but in the grasping of the common law and how to apply it.
Well, exactly how to apply. There's not really, what you need to understand, there's not that much common law left, really. Most all of the common law that is referenced today in our courts deals with questions of equity. Most of all of the other provisions in the common law are now codified. See, that's what our founding fathers had in mind. Take what the common law says is good, take it out of the common law and put it under United States statutes in the English language, printed in an organized code section so people can go look it up. They don't have to worry about trying to find a case law from 1670. Back in those days, folks, if they wanted to know what the common law said, it was a god-awful amount of reading those people had to do. Of course, now that's about all they did have to do. I mean, you know, when you get through when dark comes and you're through in the fields and you're through with the work that you can do by lamplight, then you go in, sit by the fireplace, and you'll read Blackstone's commentaries, for example, or you'll read the scripture. That's about all they had to do, was to read and talk. They weren't distracted by one-eyed monsters, whether it's in your shirt pocket or sitting in your living room floor, that don't teach you much. But anyway, I'll yield. Now, I'm sure there's another question out here.
Yeah, there's 3 more, but before we go to the next question, I looked up the procedure to do a recall, and since I mentioned I got some of the details wrong a few minutes ago, I wanted to tell you the right ones. So the steps to do a recall is to get an application. That requires 100 signatures in 15 days. That application needs to be reviewed for the grounds of the recall, and that is defined by Georgia Code 2143B. And it's that the official that you intend to recall has committed an act or acts of malfeasance while in office, has violated his or her oath of office, has committed an act of misconduct in office, is guilty of a failure to perform duties prescribed by law, or has willfully misused, converted, or misappropriated without authority public property or public funds entrusted to or associated with the elected office to which the official has been elected or appointed. Discretionary performance of a lawful act or a prescribed duty shall not constitute a ground for recall of an elected public official. Then after that application is approved by a court, the petitioners have 90 days to collect the signatures, and that quota is 15% of the registered voters the last time that office was on the ballot. That's it. All right. So Michael, you're next.
Yeah, going to the earlier discussion around the breaking of the oath. That's really interesting, and I got a couple of questions related to that. First of all, so in the case you were talking about, Judge, with you petitioned the General Assembly to impeach the people that you had found had broken their oath by because of the financial the holding the public funds illegally.
Yeah.
So if they don't do anything, what's the remedy to that? Is that grand jury time or
Yes, it
what?
is.
Okay, grand jury. Okay, so that's one thing. So first of all, or our next question is relating to if they fail to do that, are they breaking their oath? In other words, if the legislature ignores your petition, are they breaking their oath or not?
Yes, they are.
Okay, so now you can go after them as well for doing that, for not going after the people.
You theoretically you could, if a grand jury understood the causal relationship between.
Excuse me, Judge.
I'm sorry,
For-
what?
Excuse me, Judge, for some reason your volume went way down. You sound like you're really far away.
Is that better?
Yes, it is. Thank you.
Well, congratulations. Now I've got speakers out yonder and a set of headphones that don't work, but a microphone that does. So I guess I'll keep this sucker on. Okay, great. Way to go, girl. Now you made me lose my train of thought.
Okay, I'll get you back to where we were. So what I was saying is if the legislature failed to impeach based on your petition, they have broken their oath.
Yep.
And so they would be subject to a grand jury investigation too.
Yep.
For the same reason, right? Okay. So, and then, so that's part, then the next question, and I know we probably talked about this before, but remind me, how would I, as a citizen, get to the grand jury? Do I have to go to court and ask the clerk and we're back into that situation where they can, tell me to bug off or
What
how
does what does the Constitution authorize, acknowledge is your right? The Georgia Constitution and the federal Constitution both. They give they acknowledge your right to petition.
the right to petition? Yes.
Does it say in that either of those constitutional provisions that you must get the permission of someone to petition who you think might be the
No,
entity?
well, I guess what I'm getting at is, I mean, how can I just go directly to the grand jury? How do I do that? How do I find out where they are?
Yes, you can.
Okay.
As
so
a
how do I
matter of
find
fact-
out where they are?
Well,
And
okay.
when?
Of course, I could tell you, but the first comment I want to make on that is look to Beth Maggioroni in Savannah, Georgia. Look at what that woman has accomplished in almost a year of getting to a grand jury. And let me tell you how she did it. She went to the courthouse blessed by the Almighty. Believe me, that's the only way this story happened. She went to the courthouse with her ream of papers and her petition. And somewhere in the courthouse or out in front, she ran into a gentleman and they happened to strike up a conversation. And she just happened to mention that she was there to submit a petition to the grand jury along with her evidence. Well, bless Pat. He looks at her and smiles and says, I'm on the grand jury. Let me have it. I'll take it right into the grand jury room for you. Well, here, thank you very much. And he did. And the grand jury eventually summoned her to give her testimony. 2 hours.
So
Then
do you-
they weren't satisfied with that. They called the object of her discontent. Just thought of that. Okay. But anyway, they called him and questioned him. And they came back with a presentment. Hey, he's supposed to turn this information over. He's got 90 days to get it to her. Well, 90 days has come and gone. He hasn't turned it over. She goes down on the 10th of this month to the board meeting, and the rest of it is now video history. Well, it's part of video history because that story ain't over by a long shot.
Right. So is the moral of the story, you got to go to is it the superior court that you go to?
Your grand juries are convened. Let me back up. The grand jury venery. The venery is a list of citizens subject to impanelment as grand jurors. The venery is summoned to appear in court on some day at some time, 9 o'clock, usually on a Monday. Or if they're coming in on the 1st of September, it'll be the first Tuesday after Labor Day. And they all take a seat in the courtroom. Then the judge comes in, the clerk starts calling names. She's got a list where she printed out a random list of names. At least I hope they're random. And she starts calling out names. As they answer present, they usually move to another section of the courtroom so that the number 16 or 23, whatever's drawn, will be sitting together. Then the judge will I'm sorry, I forgot the entire grand jury venery will be asked a series of questions. Then the clerk goes and starts calling names. Once those names are finished calling, whether she gets 16 or 23, the judge will excuse them to go to the grand jury room, and where the bailiff will lead them to the grand jury room. And when they have chosen their foreman, their vice foreman, and their grand jury clerk, then I better call her a grand jury secretary, because a lot of times the clerk of court will also have a clerk assisting the grand jury. But once they've done that, they come back into court, and the bailiff will bring them back to the courtroom. And that's when they are sworn and charged. They will receive a charge from the court. And then they are dismissed back to the grand jury room to start their business. The minute they're sworn, they are judges. At that instance, you will have literally, you won't be aware of this, but you will literally have 2 courts sitting in one courtroom. You'll have the judge in the superior court, and you'll have the judges that compose the tribunal of the grand jury, and they will be seated there until they are excused to go back and begin their business. In the interim time, while they're out selecting their grand jury foreman, the judge will probably have maybe 10 or 20 people left over who did not get selected, and he will ask them, usually it's 3 questions. Do you want to be excused from jury service altogether? Do you want to serve on a trial jury, or do you want to be drawn for the next grand jury? And if they select drawn for the next grand jury, their names go on the clerk's next list. If they want to serve on a trial jury, then their names are put on the list of jurors for that term of court, whether it be criminal or civil. And if they want to be excused from jury service altogether, they're excused, and the clerk, puts their names back into the, well, doesn't have to put them back in the computer. They're still there, but they're excused from jury service for that term of court. And that's basically how the selection process works.
Okay, so you would go to the Superior Court then, and then you would just ask for the grand jury room, or what would you?
Yeah,
how-
there's usually
how
a
do you-
bailiff, but listen, let me explain something to you. Myself and Greg Howard got with 3 other individuals up in Walker County, and we all signed a petition to the grand jury. Now, here's what we did. We went to the clerk's office and asked, where's the grand jury? And the reason we had to ask that is because their courthouse is too small. And so they've got buildings that are not connected to the courthouse, and various county offices are in each of those buildings. One of them contains the district attorney's office and a grand jury room. So the lady pointed us across the street to a building, and we go across to the front door, and it's locked. You can't get in. Even though it's the district attorney's office, you can't get into that building. So I went and looked around the corner, and I saw another double set of doors. So I just said, hey, come on, boys, let's go try that door. Well, as we were walking to that door, we noticed a door on our right. And it was just a little bit ajar. So I said, hey, wait a minute, let's try this. This one's open. So we opened that door and step in, and lo and behold, on our right is the grand jury room with 2 or 3 people in it. Apparently they had already adjourned for lunch. And sitting to my left was the bailiff. And so we introduced ourselves, and we explained that we were there with a petition to the grand jury with additional copies for each of the grand jurors. And would he put those in the hands of the grand jury foreman? And he's, sure, I'll do that. He said, I'll take these down to the district attorney's office, and they'll get distributed. And I looked at him and I said, no, not the district attorney. This envelope is addressed to the foreman. The foreman gets this. Okay. And he said, okay, I understand. So we left. Well, guess where our petitions wound up and are still sitting as of this moment?
DA's office?
On the desk of the district attorney.
Yeah. Well, can you hand them to the foreman yourself?
Yes, you can. That
Okay,
is
so-
your constitutional right.
Because
So the
that's the
best
only
way-
way to guarantee, yeah.
The best way is not only that, but there's case law. There's an old case in Georgia, Henry Lester, 77 Georgia, 143, and on page 148, Justice Hall in 1886 made this statement, and it's never been overturned. It has, however, been affirmed by 2 other state Supreme Courts. It is the right of any citizen or individual of lawful age to come forward and prosecute for offenses against the state. In other words, the Chief Justice of the 1886 Supreme Court of the state of Georgia said to you through the halls of time, he is speaking to you today, telling you, you have the right to stand in the place of a state's prosecutor.
Wow. Okay. So now I got two more things, and hopefully I'm not taking up too much time, but I imagine everyone else is interested in this too. One would be, how do you put together a petition? But before I do that, there's a particular scenario with the Board of Commissioners in Fulton County. And I guess my first question is, are they breaking their oath? Because what they're doing is they voted to reappoint someone onto the Board of Registration and Elections, the BRE, that has failed to maintain the voter rolls, which is required by law. So they voted to reappoint people that were on such a board. And then somebody who has a reputation for challenging the voter rolls effectively, they voted against putting them on the board. Now, in my mind, that is like they are demonstrating that they are actually preventing the voter rolls from being cleaned up by doing that. And so
Well,
to me, that seems, is that a violation of their oath?
it
By-
may be and it may not be. And the
Yeah.
only way you're going to know is to read that that statute that dealt with, and I cannot for the life of me remember, 21-2- something. That statute originally made it plain that the commission has no alternative. The Democrats named two, the Republicans named two, and the law said, thou shalt appoint those four.
Right. Well, it's actually a county ordinance, and it's I believe it's 14-33.
It was, yeah, you're right. It
Yeah.
was a piece of local legislation.
Yeah, but
That
I'm
would
not,
be-
I'm not arguing on the they shall do it. I definitely agree they should do it, but I like the idea that they have a vote, like they're voting to appoint. So that means they're, deciding whether or not to appoint somebody. I think that's a legitimate function for them. But the problem is they're using that authority of oversight on the BRE to reappoint somebody who is a member of the board that consistently failed to clean up the voter rolls. And when we tried to put somebody on who is definitely going to make sure the voter rolls got cleaned up, they voted no. So, like, to me, there's something wrong with that, and I'm wondering, like, how can
How-
they? There's something wrong with that.
How do you
So,
address
is there?
that?
Well, how would you formulate that? Is that an oath break? Yeah, is that an oath breaking issue? Is that something that you can petition to
It
a grand
can
jury?
be,
Yeah.
but it may not be an oath violation of the commissioners. What might be happening is an oath violation by the board members or some of them, a majority of them. And the way you handle that is remember that your grand jury historically is an investigative body. As a matter of fact, there's a 1911 case law where the Supreme Court, the Court of Appeals judge that wrote the decision said the grand jury is a court of inquiry. They're an investigative body. They don't need the district attorney. They don't need you. They don't need me. All they need is for one member to ask a question and everybody get on board and say, hey, we need to look into that. Now they start their own investigation. Now they shut the door and nobody comes in there unless they've got a subpoena in their hand. Not even the district attorney or the sitting judge. Nobody comes in there unless they have a subpoena. And what your grand jury can do is they can subpoena the sheriff, set him down and say, look, sheriff, we got this problem. We needed some evidence. We want you to assign some investigators to bring us some evidence, everything they can get their hands on. You better believe that sheriff is going to comply because he does not want to suffer the consequences.
Wow,
Every
yeah.
politician in this state knows they may not understand fully the full scope of a grand jury's power in this state, but they know that when a grand jury says in very polite language, we recommend, none of them are hearing, we recommend. Every one of them are hearing a commandment.
Mhm.
from the mouth of Almighty God, thou shalt, otherwise you're going to pay. They know exactly what they're hearing.
Right. This is
So-
good. We need a grand jury.
So what you
so
could
last
do
question. Oh, yeah, go ahead.
is get your complaint drafted, and your complaint is your grievance to the grand jury. And then you ask in your prayers, it's just like filling out a complaint form to file a civil action in Superior Court or federal court, doesn't matter. You know, you've got a caption, you've got a style, and you've got a title. And that's the three basic parts of a pleading. And
Say that again. You got a caption?
you got up at the top, you got before the grand jury of Fulton County, state of Georgia. Then underneath that, you've got a style of the case, which is, in your case, it'd be in re or ex parte, it'd be one of the two. Fulton County Board of Registrations and Elections, or Elections and Registration, however their official title is. And then you would come down and you would say, complaint, center that. Underneath that, you'd basically state your complaint. And then under that, you could put a bill of particulars, and you could start listing each and every thing that they have done wrong that you want the grand jury to look at. And then the last item will be your prayers, what you want the grand jury to do, which they might do and they might not, because they're the ones who's got all of the evidence. They've got all of the testimony.
Wow. Do we have a sample of that we could put on there so people could get a hold of that? Because
If
I
you will
definitely
send
wanna-
me, if you will send me your email address, and for those of you who want my email address, I'll put it out here right now. It is the letter P as in Paul, my last name, Nally, Nally, the number 1, followed by at att.net. And if you'll just put on the subject line blank or petition, GJ petition, something like that, I'll send you a copy of a grand jury petition for you to use as a template.
awesome.
There
That's all my
blank-
questions. I yield.
There was a blank of the petitions that I sent out, and they are on the website where you RSVP for this class. You
Thank
should
you,
be able
Tanya.
to download them from there.
Thank you.
David?
Shirley.
Oh, you're welcome, Judge.
I forgot all about that.
Yeah. David, your turn.
Thank you. Good afternoon, everyone. Judge, I appreciate the simple language that you're putting, the Georgia Constitution into, but it just seems, dealing with some of these Board of Elections and county commissioners, they're going to do the least amount of work possible. And I'm kind of conflating moving from grand jury over to our other topic on the paper ballots, but the Constitution is one thing, but then there's going to be the case law that they're all going to hide behind. And I guess I'm kind of expressing a little frustration. I'm not sure if I have a question, but I did send you a separate chat. I did receive a letter back from my chairman of the county. Not quite sure what to do about it.
What question did you ask him?
Well, it's a different topic. It's the paper issue. There are a few of us that presented during the public comment in Houston County. I emphasized the Haldeman report that, I have a background in engineering science, that it highlights the failure modes. There were some others that presented the sections of the Constitution regarding the authority that they can move to paper. But the response that I received was that basically Judge Totenberg did not make a specific ruling in any order that they could move to paper. And
You know why that was? Do you understand why that happened?
Yeah, it's a legal dodge and or poor scholarship.
Actually, it happened because there was not enough time in her October decision for her to make that, to permit that injunction. And the reason she didn't was because there was case law precedent that she had to comply with. However, had just one of those coalition members or their attorneys raised the issue of the validity of the Dominion contract, that question has never been asked in any court that I'm aware of, not federal, not state. Nobody has challenged the validity of that contract. And had that been raised, then she could have, in spite of the 11th Circuit precedents, she could have invalidated, voided to the point of void ab initio the Dominion contract with the state of Georgia, and forced at that moment the state of Georgia to have gone to paper ballots, hand marked paper ballots, hand counted paper ballots. But she didn't, because the question was not put in front of her. Now y'all want something to do. That case, by the way, is still open.
Right.
And if any of you wanted to get together, there won't be a filing fee. There probably will be a little fee for serving notice, but you could file a motion to either intervene or a motion to join that case and raise those issues dealing with the paper ballot as it is presented to the elector when they're through pushing their selections on that screen. You see, that ballot is the minute the printer prints it out and prints it and spits it out to you, that instant, a spoiled ballot has been issued to you. And the law says those have to be set aside and not counted. And the proof is in that QR code being printed on the face of the ballot. It's not authorized in Georgia law. It's authorized in the contract. So if you look at preceding case law, the case law says you can't have an election in which you don't comply with the statutes enacted by the legislature. That's the first thing you need to know. Well, the first thing that applies to is subparagraph 3.1 of Exhibit B of that contract. So
yeah, there was someone that did make a statement about the contract during the public comment, but that wasn't responded to.
Well, they don't want to respond to it because they're going to, even if somebody put that question right smack dab in the middle of their face, you know what their immediate response is going to be? They're going to be looking like deers in headlights until the legal counsel speaks up and says,
Yeah.
"Oh, the board doesn't have the authority to determine
Right.
the validity of a contract." That is
Right.
BS. That's a lawyer lying to you.
Yeah.
That's
Okay.
all the reason they need under 21-2334. That's the only reason they need to get rid of the entire Dominion. As a matter of fact, once they make a decision, if they did make a decision, they could look over at the county attorney, which would probably be a different attorney than the one sitting there. They'd look over at the county attorney and tell him, get a hold of Dominion, make arrangements for them to pay for shipping. All this equipment's going back to them, and they're going to refund us our money because they enticed us into an illegal, void contract.
That would be a tremendous exercise of leadership that I don't think that they're gonna have.
Well, then you need to, you need to, you need to see about getting a better quality leadership.
Yeah. No, that's something else that came up during the meeting, but we have to be polite.
Oh,
So
you can
grand
be polite.
juries, pardon?
You can be polite.
No, I'm an engineer. To
I
me,
mean,
it's
no,
problem.
no.
To me, it's problem solving. You know, it's very cut and dry.
All you have to,
There's no politics.
all you have to do is look at them with a smile on your face and say, ladies and gentlemen, would you please extract your cranial cavities from your anal cavities? Now, you ain't said
I'll-
nothing bad there.
Okay.
What if-
So grand juries, what does this mean for the Trump issue that's going on in Atlanta?
I,
I mean,
I really wish we didn't get into Trump because
Okay.
that's,
Yeah.
well, but you've asked, so I guess I'm going to have to go ahead and make it plain. I know for a fact that Trump has been apprised for months, at the very least, of the power of a Georgia grand jury. And he
Yeah.
has not gotten his cranial cavity in the right perspective. So quite frankly, I don't have a whole lot of use for Trump anymore, in light of the fact that we've got DeSantis coming along, who didn't just impanel one statewide grand jury, that man impaneled 2 of them. And there's also Robert Kennedy Jr., who's now in the race, apparently. And I know for a fact from having spoken to him several years ago
Uh-oh.
that he wants a grand jury. But he hasn't found one yet in a state where the RICO laws are strong enough. His only problem with coming to Georgia was the fact that our RICO law wasn't strong enough. But if I get to a grand jury anytime soon, you can rest assured he's going to get a phone call or a text message at least. See if he's still interested. So I would prefer to keep politics out of the rule of law. Politics has done more to ruin this people. There was a time when Georgia's legislature saw to it that education in this state was handled in this state. That no longer is the case. And now today, I look at the national system and the state of Georgia systems of education, and I will look each one of you directly in the eye and tell you that those folks have done an absolutely marvelous job in educating this people to the maximum level of their acceptable ignorance.
Yeah.
And I'll let me hush. I'll yield. We're over
Thank you.
time anyway. Anybody got another question to end this session? If not, we'll turn it over to Tanny and she can send us all home.
Yep, time to go home. It's just past 4:30. Thank you, everybody, for making it today. I posted the RSVP link for next time in the chat, and that has links to the grand jury petitions, both state and federal. And thank you, Judge.
Oh, y'all are more than welcome, and thank y'all for attending. And thank you for your conversation.
Thank you.
Thank you.